Hello and welcome to our Commercial 101 webinar, 5 Essential Contracts for Your Business. My name's Alexandra Perry and I'm a practice leader here at LegalVision in our commercial and corporate team. And I'm joined today by my colleague Kathryn Wallace, who is a senior associate, also in our commercial and corporate team. Bit of housekeeping before we begin today's session. You will be emailed a copy of this webinar recording, and we will be answering your questions at the end. So please feel free to submit your questions in the chat box during the webinar. We would also be really grateful if you could please complete the survey after the webinar, which will pop up on the screen. All webinar attendees are eligible to receive a complimentary consultation to discuss how we can help you with your commercial contracts. To book a complimentary consultation, just leave your contact details in the survey that appears when the webinar ends. Today, we will be talking about non-disclosure agreements, business terms and conditions, third-party agreements, privacy policies, website terms of use, employer and contractor agreements, and at the end, we'll tell you about our Pro membership. We'll finish by answering any questions. I'll hand over to Kathryn now, who's going to speak about non-disclosure agreements. Kathryn, what is an NDA?
Thanks, Ali. So a non-disclosure agreement is a legal contract which is used when confidential information needs to be shared between two or more parties. Ideally, you should have them in place before you start having commercial discussions with another party and before you share any of your commercial or proprietary information with them. Normally, a non-disclosure agreement sets the stage for parties to then have discussions about entering into perhaps a more formal commercial arrangement or transaction. There are some key terms you need to be aware of with confidentiality agreements. So are they going to be mutual or one-way? A mutual agreement is where both parties are sharing confidential information. A one-way agreement is where only one party is sharing confidential information. Another key term to be aware of is the definition of confidential information. Is it broad? Is it narrow? Does it fit the confidential information being shared and the purpose for which it's being shared? Next is the purpose. So why is the confidential information being disclosed and what can it be used for? This is really important to be aware of. For example, if you are sharing confidential information, you want to make sure that the purpose is not too broad, so that your other party doesn't go and share it beyond what you would like them to. If you are the party sharing confidential information, then it can be, not sharing confidential information, then it can be good to have quite a broad purpose so you don't accidentally breach your obligations under the agreement. The next thing to consider is the term. How long should the confidentiality obligations apply? Standard market practice can be 2 to 3 years. However, it is not unusual where the information you're sharing is of a particularly high value or very unique for those arrangements to be perpetual. There are then a number of legal considerations or actions which step in to limit that. For example, say a court requiring the information to be disclosed, or the information becomes public other than through the other party breaching the agreement, then they're not bound by confidentiality any further. So a couple of risks to be mindful of with non-disclosure agreements and how to mitigate them. I've touched on them briefly, but be specific. If you're the person sharing confidential information, you want to be very specific about what the other party can use it for and who they can disclose it to. It would be normal for the other party to be able to tell, for example, their professional advisors the information, because normally you would have lawyers and accountants advising on any potential commercial arrangements or transactions that relate to the sharing of the confidential information. If you're receiving the confidential information, as I've said, you want the purpose to be broad so you don't accidentally breach your obligations under the agreement. A key point to consider is whether it is appropriate to include an indemnity for breach. So an indemnity is a promise to cover. For example, if the other party uses your confidential information or discloses it when they're not supposed to, you can rely on an indemnity. So that's the promise to cover. The other party promising to cover you for damages or losses that you suffer as a result of that breach. However, one thing to note is it will not stop the breach that has already occurred. It will only allow you to limit or recover some of your damages, but when it comes to information, once it's out there, it's pretty hard to put back in its box.
So Kathryn, is there a way that you can prevent someone from disclosing your information if you think that they're about to breach the confidentiality agreement?
Yes, there is. So it would be very normal to include a clause which allows for you to go and seek a specific injunction from a court. So that means if you become aware that the other party might go and share your confidential information in breach of your agreement with them, you can go to court and ask the court to stop them doing that. All right.
So I think we'll turn to business. Oh, thanks, Kathryn. We'll turn to business terms and conditions. So that's a fairly broad and generic term, but essentially business terms and conditions refer to the contract that governs your relationship with your customers. What that contract will look like depends on the nature of the goods and or services that you provide. For example, you might have a supply agreement if you're supplying goods, or a SaaS agreement if you have if you provide services as or software as a service. Regardless of the type of agreement you have, you will need to include some key commercial terms. So you obviously need to specify what the goods and services are that you're providing, the price that is payable for those goods and services, payment terms, so whether you when you get invoiced and when you pay the invoice or when the customer pays the invoice, as well as delivery terms. So if you're providing goods, when do you expect to deliver those goods? Do you have any time frames? Are they estimates, or are they guarantees that you're going to meet those time frames? It's also important to be mindful of your consumer laws, because if you are contracting with individual consumers or under a small trade contract, you will need to comply with the applicable consumer laws like the Consumer Guarantees Act and the Fair Trading Act. If you supply goods or services to individual consumers, your goods and services must meet certain guarantees and standards. For example, your goods must be of acceptable quality, they must be fit for purpose, free from defects, safe, durable, etc. If your goods don't meet those guarantees, you will be legally required to remedy a failure to meet such guarantees. And in some cases, you may be required to pay damages or compensation to the consumer for any loss or damage that they have suffered as a result of that failure. In addition to consumer guarantees, you need to make sure that your consumer terms are not unfair, or they don't contain any unfair contract terms. An unfair contract term is one that would cause significant imbalance between the parties and is not reasonably necessary to protect your legitimate business interests. For example, unilateral termination rights. So if you were allowed to terminate but the consumer wasn't, if you imposed a penalty on the consumer for cancelling early, those could be considered unfair contract terms. If you're engaging another business, you can contract out of the Consumer Guarantees Act and some provisions of the Fair Trading Act. However, the unfair contract terms regime was recently expanded in New Zealand to apply to small trade contracts. Those are contracts that are between businesses and where there's a trade relationship, and the value of the contract is, or the relationship is less than 250,000 New Zealand dollars, as at the time that the relationship between the parties was created. So that's generally as at the time the contract was entered into. This change only came in earlier this year in August, and so it's a really good time to review and update your small trade contracts, if you have any, as well as your consumer contracts, to ensure that you don't have any unfair contract terms.
So Ali, what happens if you do have an unfair contract term in your business terms and conditions?
It's a good question. Look, the regime in New Zealand doesn't have a lot of teeth, I suppose, but you do need to be mindful because it can cause reputational harm and damage. Essentially, the Commerce Commission can either, as a result of a complaint or on their own volition, apply to the court to make an order to rule the terms unfair in your contract, in which case you can't rely on those terms. So they're essentially void. However, if you then proceed to rely on those terms once they've been deemed unfair or declared unfair, you could be liable for a penalty, and the court may impose a penalty and other remedies on you.
Thank you.
Some other terms to be mindful of in your commercial business terms and conditions are warranties. So obviously, if you're engaging an individual consumer, you have certain guarantees that you need to meet. But if you're engaging another business, you might want to offer guarantees for or warranties in relation to your goods and services. You may want to say, we guarantee that, or we warrant that our goods are going to be in accordance with the specifications and be fit for the purpose for which they were created. On the other hand, if, for example, you had a software as a service and wanted to do some beta testing, you might want to offer the beta testing service on an as-is basis, because obviously it's a trial and you don't necessarily want to make any warranties or guarantees in relation to that service. Liability provisions are helpful because they can apportion your risk under the agreement. Again, you need to be mindful of your obligations under relevant consumer laws. However, there are times when it's appropriate to limit your liability. Again, taking the SaaS example, if your SaaS model had third-party inputs that it was reliant on or required a certain computing environment from your customers, you could exclude your liability or limit your liability in respect of any issues with that computing environment or third-party inputs. Finally, acceptance. Basically, how is the customer going to accept your terms and conditions? Can either be a click-wrap SaaS, whereby your customer clicks accept online. Again, really common for a SaaS arrangement. Otherwise, if you're supplying goods or services, you may want to have a agreement that's executed either electronically or in writing. It's important to mitigate your risks when entering into consumer contracts or customer contracts. So be really clear on your terms. It's important that they're clear and unambiguous, such that in the event there is a dispute, you know exactly what the contract says. Also important to be clear on when products become the customers. So when does title and risk pass in the goods that you're supplying? You can also limit your liability to the price received for the goods and or limit it to resupplying the goods and services that you provide. Now, again, you need to be mindful of what your requirements under consumer laws are, but when you're contracting out of the consumer guarantees in a B2B arrangement, it is possible to limit your liability to this if it's accepted by the other side. If you're providing goods to customers on account and they're high value goods, you may also want to think about taking security. So that can be in the form of a personal guarantee, or what's more common is registering your goods on the Personal Property Securities Register. I'll hand back over to Kathryn now. We'll talk about other third-party agreements that you might need.
Thanks, Ali. So it'll be very common in your business for you to enter into third-party agreements. So these are agreements with other persons or entities which supply your business with things. For example, supplier or manufacturer agreements. If you have a physical premises, the commercial lease for those premises, so the agreement between you and your landlord, and then if you use any software to run your business, any licensing agreements that you have in place. The key terms to be aware of in these agreements are in fact very similar to what Ali said for your own business terms and conditions, but you need to look at them through the other lens. For example, the obligations of each party, who is doing what, who's supplying what, on what terms is it being provided to you, who's responsible if it's goods, for example, delivery or collection. Other key terms are price and payment terms. So what are you paying them, how much, how often, and what happens if you're late in paying. Title and risk, so when do the goods become yours, and when do you take risk in the goods, so when do they become your responsibility. It is very normal for title to pass on payment of the price, so once you pay your supplier or your manufacturer for the goods, then they become yours, and often risk will pass on delivery. So for example, if you are having goods shipped to your premises, once they arrive at your premises, then they're your responsibility. Warranties. So these are promises. What promises are you making to the other side about your business? It's very important that you look at those to make sure that you can actually give them to the other side. Otherwise, you can technically be in breach of the agreement. Liability. Where does the risk sit and how is it apportioned? So how much can you recover from the other side if something goes wrong, the goods are faulty or damaged? And what can the other side gain from you, or how can they come after you if something goes wrong at your end under the agreement? Another key provision to consider is the termination. How can you get out of the agreement if your relationship sours, or you're not happy with what's been supplied, or you just need to find another supplier, or there's another reason? How can you get out? Can you terminate for convenience, which is for any reason? If so, what is the notice period? Or can you only terminate if there's a breach or at the end of a particular period? It's really key that you are aware of how long you're locked into these kind of agreements for, because obviously your payment requirements are going to continue under those agreements. And then security. Does the supplier or your manufacturer require a personal guarantee from you? This is quite common, and often you would see these in a commercial premises lease, where the company, for example, is the tenant, and then the landlord requires a direct guarantee in support of the tenant's obligations under the lease. So a guarantee will kick in only if, for example, again, the company who's the tenant fails to pay the rent, as an example, under the lease. Then the landlord can come to you and call on that guarantee and ask you personally to pay that amount. Now, guarantees can be quite scary. They can also be quite far-reaching documents, so it's really important that you have a lawyer look over the terms of that and advise you on what exactly it means if you are signing a guarantee. Mitigating risks under third-party agreements. So first of all, be aware that the contract, if it's being provided to you from the other party, is most likely to be favourable to them. So you need to look through and think about, okay, this isn't going to benefit me, so where can I perhaps make some changes to even the playing field? And this is where a lawyer can really come in handy, because we see these kinds of documents all the time and are very aware where we can make changes to balance things out. Again, look for the apportionment of risk and when the title and goods changes to you. And also ensure there are remedies. So what happens if something goes wrong, the other side breaches, or if what you've been provided is not what it's supposed to be. It is really important that all of these key terms are clearly set out in the agreement so that there can be no argument should a dispute arise. I'll now hand over to Ali, who will talk you through privacy policies and website terms of use.
Thanks, Kathryn. Protection of personal information is a bit of a hot topic, and it's important that you are clear about how you handle personal information when you collect it. Legally, you're required to notify an individual when you collect their personal information, and personal information is defined reasonably broadly as any information about an identifiable individual. This includes emails, names, phone numbers, contact details, anything that can identify your customers as an individual. And as technology develops, what constitutes personal information also evolves. So, for example, geolocation data is personal information, and other information that may not necessarily have what you consider identifiers attached to it would be deemed personal information if it's in combination with other identifiers. A privacy policy sets out information that you collect from an individual, how and why you collect that information, how you store it, how you use it, and who you disclose it to. In addition, it should specify how an individual can access and correct their information and how they can make a complaint if they think that their information has been handled in a way that is not in accordance with privacy laws. If you're likely to disclose personal information or store personal information overseas, you should include that in your privacy policy and ideally mention those countries where you are intending to disclose or store that information. It's also important to note whether your website uses Google Analytics, geolocation, APIs, and or cookies. You might be wondering why we've got a section on the GDPR or General Data Protection Regulation, which is an EU directive. It may apply to you and your business even if you're not established in the EU, but you offer goods and services to customers or individuals based in the EU. This can be anything from offering goods or services on your website in euros or advertising that you deliver to certain countries in the EU. Individuals in the EU have extra rights under the GDPR, and therefore it's important to understand your obligations under the General Data Protection Regulation and ensure that any data you collect from individuals based in the EU is compliant with the GDPR requirements. The GDPR requires you have a compliant privacy notice, and this is something that we are able to assist you with, as we have a team based in the UK who have expertise in GDPR. The next slide, we have website terms of use, which are not really legally necessary or required, but can be a nice to have. Website terms of use set out the rules for visitors using your website, such as what a user can do and what is prohibited. It covers any content that they might upload and may include disclaimers around your liability when individuals access your website. If you operate an e-commerce website, these types of terms would generally be incorporated into your business terms and conditions, and therefore it's not really required. If you supply goods in person or outside of your website, you may want to have some generic website terms of use, but be mindful that they aren't always legally enforceable and don't carry much weight. Now for our final topic, which is employment and contractor agreements. Back to you, Kathryn.
Thanks, Ellie. So employment and contractor agreements, again, another key commercial agreement you will most likely enter into if you run a business. So there are some key differences between contractors and employees. A person who enters into a contract of service is an employee, and a person who enters a contract for services is an independent contractor. However, that is a very, very basic summary, and in fact, a court would look at the nature of the relationship. So just because a contract says it's a contract agreement doesn't necessarily mean it is. If there was ever a dispute, a court would look at the nature of the relationship between you and that person and then make a decision based on that. So key differences between employees and contractors. Under the Employment Relations Act, employees have various employment entitlements. For example, they must be paid a minimum wage, there are break entitlements, and there are statutory leave entitlements. You are also mostly responsible for returning PAYE to the IRD in respect of that employee, whereas contractors will organise their own taxation and superannuation. Key terms of each agreement. So an employment agreement. Is the position casual, full-time, or part-time? Is the agreement permanent or fixed? These are really important things that you need to be clear of at the start of this relationship so there's no confusion down the track. Duties. What are the roles and the responsibilities you are requiring this person to carry out? It is really important that these are clear because any change to an employee's duties or roles or responsibilities actually requires a full-on consultation process, which can lead to personal grievances if not done properly. Working hours. What hours are you expecting them to work per week? That's really important to specify, as is how much you are paying them. And with the salary, you should specify whether it's in addition to KiwiSave, whether KiwiSave is in addition or whether it's included in their salary. It is also common for employees to be provided additional benefits such as a company car, a petrol card, mobile phones and laptops, and also set out how that employee can end their relationship with you. How much notice do they have to give you? It's quite common for it to be 4 weeks, is one that I've seen quite often. And then annual leave. So there are the specific statutory requirements regarding leave, but you can also add discretionary leave if that's up to you. For example, at LegalVision, we get birthday leave, which is 1 day during our birthday month that we get to take off. In terms of a contractor agreement, what are the scope of services they're going to be providing you? This is similar to the employee's duties. It should be really specific, so there's no arguments there. Intellectual property. If they're going to be creating intellectual property in the course of their employment with you, for example, if they're an IT contractor, who's going to own that intellectual property? It's really important you set that out. Ideally, it will be you, but I have seen agreements which say differently. Price and payment, what terms are you paying on? What terms are you paying them? How much and how often? And restraint of trade. Are they prevented from contracting to similar businesses or from taking your employees to join their business? It's really important that that is clear, and also you need to be mindful that those restraints have to be reasonable. And there is a whole lot of court cases which set out what can and can't be enforced in that context. We have a specialist employment team who can help you out with any of your employee and contractor agreements and also advise you on any issues that arise. One key thing to be aware of is that the government is currently looking at the definition of an employee, because there has come to light some cases where what they're terming vulnerable contractors are considered contractors, but actually they're technically employees, and this is in the case of courier companies at the moment, but we understand that Uber drivers and the like are also being considered for this purpose. That ends the main component of our webinar. You might also find our free publication, the Commercial Contracts Checklist, helpful. Please download it from the handout panel. We also have an upcoming event that may be of interest to you. This is the Startup Founder Guide to Employee Share Option Schemes, and it will be held on the 10th of November at 11 AM New Zealand time. Employee share option schemes can be really useful if you're a startup business and you want to get your employees on board but can't afford to pay them market salary. You can instead offer them shares in return for their service. So this is quite a common mechanism used in new businesses. We'll be answering your questions shortly. While you submit them via the chat box, we'll tell you about our membership. So LegalVision's membership is a cost-effective alternative to the hourly rates you experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document reviews, document drafting and amendments, reviewing third-party agreements and other commercial documents, and providing you with advice on them. It also includes unlimited advice consultations with our team of 100+ specialist lawyers, including business structuring, employment, disputes, IP, and more. We also offer unlimited domestic trademark registration services. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how membership can help you, request a free consultation when the survey appears at the end of this webinar. We will now answer your questions. So,
right,
Ellie, I have a question for you.
Go for it.
If a contract is terminated and I've provided services under that contract but haven't yet invoiced for them, how do I recover them?
Well, hopefully your agreement allows for you to invoice your services that have already been provided, and even if the contract terminates, you can still send out that invoice and have them pay that, because the services were provided during the term of the contract, and therefore the obligations for them to pay for those services still exist.
I see. That's very interesting. Thank you.
And there's also another one here that I'll answer. I've seen come through. do you need a privacy policy for the business's Facebook page as well? Your privacy policy is generally just one document if for your one business, and you can have that. You should have that on your website, and also provide information to individuals every time you collect their information. So you don't necessarily need a separate privacy policy for your Facebook page per se, but in your privacy policy, you should address the fact that you might collect personal information from people when they interact with your Facebook page.
That's very interesting.
Kathryn, another one here is, how can I limit my business's liability?
Okay, so
I'm assuming that's in customer contracts or third-party agreements.
Yes, so say, for example, in a customer contract where you're supplying goods or services to the customer, it's very common to specify that those goods or services are limited, your liability for those goods or services are limited to them being resupplied, or you paying your client the price that they have paid for those goods or services, i.e. they can't get more money back from you than what they've already paid. And in the case where you've got a third-party agreement, you would actually look to potentially remove that provision and for the third party, and then for you, make sure that any liability of yours is actually limited to things that are within your control.
It's also really common to see an exclusion for consequential losses in some agreements. And if you're supplying services or goods, you would want to exclude your liability for consequential loss, which is suffered by a customer. Now, consequential loss is a interesting, a bit of a complicated concept, but I'll do my best to give it a go and explain it. They're essentially losses that are not directly are not direct losses from a breach of an agreement or non-compliance with certain terms. Sometimes it can include things like loss of profit or loss of revenue, but you want to be really specific about what you deem to be consequential losses in your definition, in your agreement. So we always define consequential loss really clearly to include things like loss of profits, loss of data, loss of revenue, particularly when you're the service provider. Obviously, you need to think about it a little bit differently if you are the recipient of services or goods.
Thanks, Sally. So we've had a question come through here about providing template contracts for a particular type of business. So we don't have template packets that you can purchase, or contracts that you can purchase per se, but we can help put together those contracts for you. And that means you'd be able to have a set of, for example, template or master contracts that you can just roll out and use in your business. And if you have any questions or any changes come in from third parties who present those contracts to you, then that's something that's included in our membership as well, and that we can assist you with.
We have a question here about permanent full-time contractors and hours. Now, unfortunately, that's a question, as we're in our commercial team, it's not a question we can assist you with, but our employment team would be able to answer that question for you if you wanted to book in a consultation and understand about our services after the call, after the webinar today. And just remember that is a free consult, so do sign up and use it. Can you use terms and conditions and policies from other websites of similar trades and services? Kathryn, do you want to answer that one?
Yes, so the answer is yes, you can. However, they might not be fit for purpose. And you may, depending on how bespoke those terms are, there could be IP considerations or intellectual property considerations there too. So we would recommend that we put together some terms for you that are tailored specifically to what you're offering and consider your business when they're put together.
Yeah, it's a great point. And you see a lot of the time, particularly with things like privacy policies, because obviously they're freely available on people's websites. And sometimes when we've reviewed privacy policies for our clients, it's really clear that they haven't considered exactly what they're doing with that personal information or when they collect it, and they've just used a sort of a bit of a stock standard template or copied something that's already in existence. So it is really important to tailor your agreements, your privacy policies, and make sure that they're fit for your purpose.
So Ellie, with a privacy policy, if you're using something, say like Google Analytics or geolocation data, do you need to tell people that that's what you're doing?
Yeah, you do, because it is, you are using personal information. Now, when you, under privacy laws in New Zealand, you can use personal information that you collect for certain purposes, generally for the primary purpose for which it's collected. So, for example, if you're my customer, you're ordering some goods from me, I obviously need to collect, your contact details and address so I can deliver those goods to you. Now, if I then use those contact details for another purpose that you haven't agreed to or I haven't advised you of, then I might be in breach of my obligations and under the Privacy Act. So when you're taking geolocation data and APIs, that's still personal information when you collect information using those tools, and therefore you do need to be clear to individuals that you do that.
Thank you.
It doesn't look like we have any other questions as of yet, so I guess we will wrap up here.
Yes, so if you would like to request your free complimentary consultation, which you're eligible to receive, please leave your contact details in the survey that will appear after the webinar ends. That's all for today. Thank you so much for joining us, and we hope to meet you.
Thanks.
See you.